All right, good morning, everybody. My name is Mary Leonard. I'm chair of the Department of Pediatrics, and it is my great pleasure to welcome you this morning to Pediatric Grand Rounds. And you'll hear in a moment, we really have a wonderful topic for today. And we are ending the Grand Round seasons in the next few weeks on a very strong note. So as always, at the end of the year, we hear from our chief residents, and they're going to be speaking about applying our values of transparency, empathy, and advocacy to improve pediatric residency. And then we are very fortunate the following week, which will be the last session of Pediatric Grand Rounds in this academic year, Dr. Matthew Myers from UCSF is going to be speaking, and he's a leading educator in transgender care, a really compelling body of work. So very excited about that. On the left, you can see all of our housekeeping, your CME, your MOC, all that good stuff. So the university land acknowledgement, we recognize that Stanford sits on the ancestral land of the Molecular Ohlone tribe. Land was and continues to be of great importance to the Ohlone people. Consistent with our values of community inclusion, we have a responsibility to acknowledge, honor, and make visible the university's relationship to Native peoples. All right, and Pediatric Grand Rounds, just to give you a snapshot of great things coming ahead. We're so fortunate that Bob Vinci is going to be kicking off the Grand Round season in September. Followed by our Med Ed Forum, as you can see here. And then it's really just a great lineup of international speakers. And we were just talking about the fact that the incoming president of the American Academy of Pediatrics is also on our roster for Grand Rounds, interestingly, on Election Day in November. So that will be good, I'm sure. And here, just some more housekeeping, just that Pediatric Grand Rounds, just because of some of the vagaries of our access to space, it is in person most days, and we encourage people to join us in person, but there will be a couple that are Zoom, so keep an eye out for that. And we're very excited on Thursday that we're having our inaugural Stanford Medicine Children's Health Research Community event. We've been talking about this now for months. Really exciting chance for hospital administrators and Maternal and Child Health Research Institute staff, the Clinical Research Support Office. Everyone is coming together to talk about the many, many ways, many new programs we have in place to support clinical research. And with that, it's my great pleasure to welcome Michelle Mello. I was just saying to Michelle, given the extraordinary depth and breadth of the work that she does, we almost need to have her come speak to us annually. Today is particularly timely because on Friday, there was a discussion in the Dean's Exec among leaders across Stanford Medicine, and the exact question came up of what is the liability risk from AI tools in patient care? And I said, oh, Tuesday at 8. So just briefly, Dr. Mello is a leading empirical health law scholar whose research is focused on understanding the effects of law and regulation on healthcare delivery and population health outcomes. She has a joint appointment here in the School of Medicine, the Department of Health Policy. She's an author of more than 250 articles on medical liability, public health law, the public health response to COVID-19, pharmaceuticals, vaccines, artificial intelligence, data ethics and privacy, biomedical research ethics, governance, gender bias and harassment, clinical trial diversity, and other topics. So you can see when we were inviting her, we thought, wow, there's so many things we could ask her to speak about. Her publications appear in medical health policy and law journals. She serves on the editorial boards of JAMA Health Forum and the Journal of Health Politics, Policy and Law. She is the recipient of many esteemed awards, a member of the National Academy. She's garnered the Alice S. Hirsch New Investigator Award from Academy Health, the leading professional organization for health services and health policy research. She is a Greenwald Faculty Scholar, that award recipient. That's a word that's near and dear to us because we have somebody who recently was awarded a Greenwald Award in bioethics. She's an RWJ Foundation Investigator Award in health policy research. And I could go on. And Michelle, I had a chance to look at some of your papers recently and on this very topic. So we're really excited to have you here today. Welcome.
Thanks very much, Dr. Leonard. I was having my deposition taken yesterday by a real lawyer who spent about 10 minutes going over my background at the beginning. So you have a master's degree, you went to Yale Law School, and you've got a PhD. And then she paused and said, but you're not a medical doctor, are you? You have no medical training at all. None. You didn't go to a medical school for one day. So I'm very aware that I'm in the presence of superior expertise. And I hope we can have a dialogue today. I think we're beyond the point where any of us wants to hear somebody lecture for 40 minutes uninterrupted. So please feel free to interrupt. I see there's a mic there. I'm more than happy to pause and just talk as we go. As Dr. Leonard mentioned, I'm going to be talking about some work that I've been doing to try to understand an issue that it has become clear to me is very important to physicians as they increasingly have encounters with AI tools in patient care, which is how might all of this affect my medico-legal risk? It's not only physicians that are worried about this, but also healthcare institutions like Stanford Healthcare, as it makes decisions about which tools to adopt and how to deploy them. My sense is that AI use in pediatric care is lagging a little bit behind its use in adult care. But there seems to be tremendous optimism, maybe over-optimism, about the prospects for permeation into pediatric care and addressing shortages in pediatric subspecialists in underserved areas, making it possible for you all to do more. So I think, as with other areas of patient care, this course is sort of inevitable, and the question that interests me is how do we manage this transition to AI-enabled care responsibly, and to the extent that harm occurs, which it will, make sure that liability for that harm is allocated in a fair way across all the people in the ecosystem that are involved in using AI. When you speak to lawyers about this topic, actually, first of all, let me just make a couple of disclosures. I do have some relationships with companies that make AI tools or platforms that power those tools. So I want to start with understanding a little bit about AI risk, the liability risk that we think might arise from AI tools. And I'll talk about a study that we did to try to understand what's going on in the courts about this right now. And then I want to close with some recommendations for responsible management of that liability risk. Now, when you hear from my colleagues in the bar on this topic, many of whom make their livelihood by advising institutions about risk management, they speak about AI adoption as kind of this mushroom cloud of horribles. So you can see that this is a screenshot from a continuing legal education seminar for hospital lawyers. And you can see that the lawyer has arrayed all of the terrible consequences that could rain down on an organization that chooses to involve itself in using AI tools in patient care, everything from getting in trouble with CMS for compliance problems to having patients sue you, reputational harm, and so on and so forth. And one of the instructors in that CLE course called this a disaster for healthcare providers. I think it is important to recognize this is how lawyers keep the bills processing in law firm offices, is raising concerns and making people spend time addressing them. Having said that, I do think there are some legitimate reasons for concern here. And I'll just sort of give the rundown of why, as a lawyer, I do see some issues here arising. And number one is that compared to other kinds of technologies that we roll out in the hospital, right now, these tools just get much less vetting. Most of them do not go through FDA clearance. They don't have to, and they actually can't. And there's, in most institutions, a relatively light or no process of institutional vetting. That's not true here at Stanford. I think our process is actually quite rigorous. But there's just less development of the evidence base for these interventions compared to other things. And this has led, I think, to very reasonable concerns that the basis on which organizations are adopting these tools, in fact, is kind of the sales pitch that developers give them. And they're having to rely on testing that the developers claim that they have done, with actually not much ability to kind of validate what has been done or make sure that it applies to Stanford patients. So I think that's a reason for concern, that there's risk in here. It's hard to evaluate how much risk there is in a particular tool because of the limited amount of testing involved and other factors. And then I'd add to that a host of other things. One reason to worry about liability is that historically, when we've had a technology or a service or product that has been very lightly regulated by formal regulatory bodies, the courts fill that gap. When people start getting hurt by that thing, and there's not a formal system of regulation, torts will apply and expand tort liability, personal injury liability, to fill the gap and make sure that people have legal redress. And that is certainly a description that I would apply to this set of technologies. In terms of the magnitude of the risk, a problem is that a lot of these tools would presumably make errors that would propagate over large groups of patients, in contradistinction to the kind of garden variety instance of medical malpractice, which is on a single patient. Then we have to think about, well, what does the potential pool of jurors and plaintiffs look like when we're assessing liability risk? And we've got a public right now that has a very high degree of distrust in AI generally. A poll conducted last year found that about 60% of Americans said that they would be uncomfortable with AI tools being used in their healthcare. So again, when we think about the priors that a juror would be seated in the courtroom with, or the conclusions that the mother of an injured patient might leap to when she found out that an AI tool had been involved in care that involved an adverse event, this distrust matters. Add to that the reputational harm that surrounds AI associated events. These are sexy events from the media's perspective. They're likely to attract a lot of public attention. And when these cases get to a court, which we should acknowledge is rarely, most malpractice claims get settled quietly by the insurer or dismissed. When they get to a court, they come to a judge who is going to have little or no experience adjudicating this kind of claim, because these kinds of claims are pretty uncommon. And finally, because they're uncommon, as I'll talk about, the doctrine in this area is very underdeveloped. It's in its sort of legal adolescence. So it's just unclear when courts are going to say it's the developer who's liable, or it's the hospital that's liable for picking this tool or not maintaining it, or it's the individual physician who's liable, or in some cases it might be the patient if there was some interaction with patient decision-making in the tool. But what we do know historically is whenever these doctrines have been underdeveloped, physicians tend to get left holding the bag. They're the easiest party to rest liability on because of all kinds of other doctrines that just make it kind of hard to hold healthcare organizations liable. And because commercial product makers are very good at disclaiming liability, as I'll talk about. So physicians are, what we call in legal scholarship, the liability sink. They're like the sponge that absorb all this excess liability. And so it's understandable that physicians worry about this. And all the early signals, I think, from developers, as well as actually from the US government and its regulations, are that ultimately it's the human in the loop who is responsible for making sure that AI gets used in a competent way, and that's you. There are, I think, some special concerns that arise for pediatric care, and these, I would guess, are not surprises to you. The tools that we have are mostly being trained on adult data sets because that's what's available at the scale that is necessary to train some of these tools and tune them. And until we have greater data equity and availability for pediatric populations, it means that we might have to make inferential leaps about how a tool is going to work for kids based on data that are not about kids. Similarly, when it comes to validating a model that's already been trained, a lot of that validation work might be performed on patient populations that look very different from those that you treat. Even if they are trained, even if they are validated on kids of what age? The anatomical differences in kids across their maturation means that there's this special need for a large amount of data on a very narrow slice of patients, and that kind of data is just not available. Similarly, when the developer makes instructions for how do you use this tool, or what works well about the tool, what are the pros and the cons of using it, what should you be on the lookout for, it's likely that all of that comes from data that is not specific to kids. So a tool may perform well for adults and not so well for kids, and you might not be aware of that or told about it. Because kids are a smaller population, they are healthy most of the time, there's also just less of a market target in the pediatric population. So developers' incentives are to make tools for common diseases or common health conditions where there are big markets. And I think the implication of that is that there are probably just fewer tools available that are developed specially for kids. That means fewer choices in the market. You may have to accept higher risk or lower validated tools. And then finally, from a lawyer's perspective, kids are great. They're wonderful plaintiffs. They're super cute. They have long lifespans in which their disabilities can propagate into very large damages awards. And so as a lawyer, you always think about, well, not just how likely am I to hurt this, to have the kid that's hurt, but also how likely am I to get damages out of this case? These are cases that are very, very attractive, very likely to settle early, and therefore very likely to find a lawyer willing to take them. So those are all reasons why I would be especially concerned about liability risk for pediatric tools. But now I just want to shift gears and deliver my main message, which is that although there are reasons for concern, I think that the risk is very manageable and shouldn't impede adoption of tools that stand to benefit patients. Nor should we ever forget the counterfactual, which is that, as you know, as I was talking with Dr. Chamberlain about the arrival of July 1st, we live in a world of imperfect human-centered care, where errors happen all the time, safety violations happen all the time, and particularly in some areas like diagnostic error, we just have not been able to make that much headway on reducing adverse events. So there's enormous promise around these tools, and it would be a real shame if adoption was chilled because of this liability risk. And there's a real danger of that happening, right? Physicians are sort of notorious for practicing defensively in the face of uncertainty about their liability. The value proposition for these tools is already pretty marginal for a lot of healthcare organizations that might be considering whether to pay for them and adopt them. It's not clear that they're going to save a lot of money or generate a lot of revenue. And this can kind of tip the scales. And then from the developer's perspective, their cost of capital is affected by liability risk and uncertainty. The more liability risk there is, the more expensive it's going to be for them to get the money that they need to develop their products. And so ultimately, this liability fear affects the nature of innovation that happens, what kind of tools are available to patients, and at what price. So it's really important. And I think it's important that it's not overestimated. So let me offer a few basic reasons why I think we shouldn't get too carried away here. So one is just the basic epidemiology of medical malpractice litigation. This is something that I spent quite a bit of time looking at in the non-AI context. And what we know, and you probably heard this statistic, is that if you are injured in a hospital in the US today, and you have an injury that we would call, eligible for compensation in tort, like it relates to negligence, there's a causal association, still only 2 to 5% of those patients will ever bring a malpractice claim, even though they're eligible. They have an injury that's qualifying. There are lots of reasons for that. The main one is it's super hard to get an attorney. Most physicians don't appreciate how hard it is. But plaintiffs' attorneys are very selective about the cases that they bring, and most people find it impossible to get a lawyer and therefore impossible to bring a claim. So already, almost all of the instances of negligent care that lead to injury in the US healthcare system result in no consequences in terms of liability. And I would not really expect that to change very much. In fact, I would expect it to go even lower because, as I'll talk about, these claims can be really hard to prove, these ones about AI. The second point of reassurance is that when we looked for these cases, we didn't really find a lot of them. And I want to offer the caveat is that what we can observe in the system is only those cases that reach a court. And again, a lot of this stuff would get resolved kind of sub rosa by insurers. So if you really want to know what's going on, you need to talk to Summit. But when we look at what's going on in courts, there's not much there. So we looked in a pretty rigorous way for any cases that involve personal injury, so like not economic injury, but a personal injury and software for the last 15, 20 years. And we found over 800 of those cases, only 51 related to the use of some kind of software tool and a personal injury that sort of met our criteria of like a physical injury, the kind of injury that you all would be worried about. And not all of those were in healthcare. So it's rare that these cases get very far, to the stage where we'd have a written judicial opinion. There may be more going on, but when I talk to insurers, I don't hear that this is a major issue yet. And the last issue, and maybe the most important, is that when I think about the kind of proofs that these plaintiffs have to make in these cases, it's really hard. It's already really hard for plaintiffs. Plaintiffs lose 4 out of 5 malpractice trials. You look at all the claims brought, they recover only about half the time. And again, those are the claims that some attorney thought was good enough to bring in the first place. But there are some special hurdles for plaintiffs in these cases involving AI. So let me give you like a little taste of what my tort students get their first 3 months at law school here. Let me talk to you about what a plaintiff has to prove in a case and then why it's so hard in these cases involving torts, at least insofar as we could tell by reading a lot of these opinions. The first thing you have to show is that the defendant owed the plaintiff a duty. When it's a physician, that's easy. As long as there's a treatment relationship, there's a duty. But when we think about bringing in a software developer, an AI tool developer, it may be quite hard because actually there is a doctrine that says that if it qualifies as a certain kind of medical device, which some kinds of software does, all state law tort claims can be swept away under a doctrine called preemption. There's a federal statute that regulates medical devices, and the Supreme Court has said that statute means that there can't also be regulation by the courts. So this doesn't insulate you as a physician, but it insulates a lot of the software developers who may be kind of the deep pockets in this litigation, especially if it's litigation over like a defect in a tool that propagated, nationally. May be quite hard to establish duty. Second, you have to show that the defendant's conduct fell below the legal standard of care. I'll talk a little bit more about that later, but for now, let me say that it is different if it is a product maker versus a physician versus somebody else. And regardless of the particular standard, there are some things about AI that make it kind of hard to prove. Mostly what makes it hard to prove is the opacity of these models. It's very hard to look inside them and understand how they work. And that matters for product liability because you have to show as a plaintiff that there's a defect in that product. Not just that it hurt you, but that it hurt you because it was defective, meaning it was unreasonably dangerous. There was something wrong with the design of the product. How do you do that for an algorithm that's encoding statistical patterns, potentially over tens of thousands or hundreds of thousands of parameters? It's really hard. And then even as we think about this issue as it applies to the physician, the argument would be a little different. It would be that the physician violated a reasonable standard of care in relying on the output of this model, or maybe by choosing not to rely on the output of this model. And then the plaintiff has to go through the process of establishing how other physicians would think about that decision to rely on the output. There may be no custom established about that. And it's also the case that these models are known to perform well on average, but how do you prove that it was unreasonable to rely for any particular patient? You would have to have evidence that it was known or foreseeable that it wouldn't perform well for this particular patient or patients that look like this particular patient. Again, that's just really hard to dig up that kind of evidence. And that makes these kinds of injuries unforeseeable. And if it's unforeseeable, you can't be held liable for medical malpractice. Finally, layer on an additional wrinkle is that courts seem uncertain about whether software is a product. And that matters as to whether we can implicate product developers as defendants here and apply doctrines of product liability to them. Most of the case law around software comes from stuff like investment software that malfunctioned and somebody lost money. And courts have not been willing to call that software a product. Now that we're in the Internet of Things and we've got AI-enabled cars and things like that, it becomes easier for them to view it as products. But again, it's just not clear that plaintiffs would be able to implicate a developer in any of this. And then finally, the plaintiff has to show causation, that they were hurt because of the defendant's negligence or the product's defect. And just to reiterate the point here, you can't just show that the product made a wrong prediction and you were hurt by it. You have to show that that wrong prediction happened because the product was defective. Or to make the analogy to the physician's negligence, the physician relied on it in a way that was unreasonable. And again, if you can't really look inside and understand why it generated the output it did, how can you argue that you were injured because of a defect? How can you argue that a physician's reliance on that was unreasonable? So these are real hurdles. Even a really seasoned and savvy plaintiff's attorney would have a tough time with this kind of stuff in most cases. And that means, I think, for the time being, that even if these claims are brought, they're going to be really hard to win. They may be settled because there is an interest in not having the case publicized in the newspaper, but it would be very hard, I think, to prevail in courts for a lot of these claims. Now, having said that, again, historically, when courts have seen a gap, there's a group of people that's being injured, especially by a product, and they're having trouble finding legal redress, they create a patch for that bug in the system. So product liability doctrine especially has really evolved since the 1960s and the rise of the consumer movement. It was initially super hard to hold product makers liable when their products hurt consumers. Now it's super easy because courts saw this gap. They stepped in and made plaintiff-friendly doctrines. I have every expectation that that will happen here. if it continues to be the case that this is a lightly regulated product and plaintiffs' attorneys really struggle with these traditional proofs, I think courts will modify the proofs again to make it easier on plaintiffs. So this kind of adolescence that the field is in, I think, is not going to hold. But that's kind of where I think things are now. And to buttress that, I'll just say a few words about the review that we did. I said we found about 50 cases where these kinds of personal injuries arising from software made it all the way to a judge, and there was a written opinion. And I think these cases, they offer kind of limited insight into how courts are going to handle these claims, but they do tell us two kinds of things. One is, what are the fact patterns that are likely to end up in court? And secondly, what are some kind of problem areas that we can already spot in how judges are dealing with them? So these are the three main kinds of fact patterns that we saw in these cases. So one is like some kind of software that's used to manage like operational functions or overall clinical functions in a hospital that fails in some way. In that case, the typical defendants are the software developer and the hospital, because it was the hospital's decision to buy this thing and implement it, and it was their responsibility to monitor it. And so here's a couple of examples of those kinds of fact patterns. And I think these cases really underscore, obviously, the need to vet very carefully the choices that a hospital makes about tools and the obligation to monitor them after they're deployed to make sure that they're working as advertised. The second kind of fact pattern implicates physicians a little bit more. These are cases where the software made a recommendation, the physician followed it, and something bad happened. In these cases, it's the physician and the developer that typically gets sued. Here's one example of the algorithm was just, I think, just very poorly designed. It was a cardiac risk algorithm that relied solely on a series of lab tests, not taking into account family history, if you can believe that. And the physician chose to follow the output. This young man whose father had died of a congenital heart defect died 6 weeks later. So maybe that's kind of an easy case where you can't imagine why a person would either accept such an algorithm or follow it. But we always have to ask, what did the physician know about this algorithm? Was there enough questioning going on? And then the final set of fact patterns tend to involve like physical devices that have AI embedded in them that fail. And in those cases, everybody gets sued. And I think those are probably the easiest cases to make out as a plaintiff, because you've got a physical thing. The doctrine's just a little bit better developed there. So these are the kind of fact patterns. I said we can also learn a little bit about some of the challenges that judges are having with them and that plaintiffs' attorneys are having with them. And the first is that these sort of theoretical predictions that I made about doctrine are kind of borne out here, that because these models are really hard to see into, it's quite hard for the plaintiffs to make their claim. And often these lawsuits get thrown out at a relatively early stage before they get to trial, because some core element of proof is absent at that stage. Like, what's the defect? I know something bad happened, but what was wrong with the math inside the model? The second is that a lot of these cases turn on the question of whether the physician should have known that this patient wasn't suitable for the algorithm to make an inference about. And in some cases, that's reassuring, because I think there's a very clear action step that arises from that. And we can talk a little bit more about that in terms of making sure you understand what the model was trained on and what it works well, what kinds of patients it works well for, what kinds of patients it doesn't work well for, and what kinds of patients we don't know if it works well for. And there's also clear action steps for hospitals in terms of how they roll out tools, that you want to start with beta tests in populations that look the most like the ones that it was trained on, and then tune before you expand it. And then a final observation we made that was a little bit concerning is that judges, when they talk about these technologies, don't make any distinction between regular software and AI-enabled tools. I don't think they get it, or at least they didn't at the time that these decisions were written. And so, they don't fully understand issues like model opacity or distribution shift, things like that, that have become really core problems in the field of AI evaluation. And it's worrying to a legal scholar, because there's the danger of judges adopting rules, thinking about one class of software and applying them to another where things are actually very different. For example, maybe they make it easier on plaintiffs to prove some of these things because they have an AI case before them and the lawyers go on and on about opacity. They don't need that rule for non-AI tools. We understand what goes into other algorithms that are simple, but they would probably apply it anyway. So again, judges still figuring this out. It's early days, but there are some real challenges for plaintiffs here. So let me conclude by talking about some things that I think physicians and hospitals can do to try to address and manage this risk. And again, I'm not of the opinion that this risk should serve as a barrier to adoption of a tool that otherwise there's a good case for. I think the first thing we can do is calibrate adoption decisions to the actual level of risk in the tool. I think there's a tendency to talk about AI in a very general way. What is how much liability risk does AI involve? Well, the lawyer's answer is always, it depends. And that's definitely true here. It depends on the tool. It depends on how the tool is used. And it actually depends on the sort of optics of the case as well. So let me walk you through a framework that is what I would use if I was a physician trying to evaluate the risk associated with using some tool. I'd start with the tool itself, and I'd say, what do I know about the likelihood and the nature of errors that could arise from this algorithm and from how it's being implemented in my hospital? So the developer will have to disclose some kinds of information about its predictive value, for example, hallucinations, the training data, the shortcomings of the training data, et cetera. And hospitals need to get in the business of asking really hard questions about all of those things before they deploy, not just deploying because of a sales pitch. Errors will also arise, of course, because of how clinicians relate to the model. So it's also really critical to think and ask hard questions about, should I follow the model in this particular case? Again, that relates back to what do I know about how it was trained? A major source of risk that we see emerging, frankly, when we look at actual deployments here at Stanford Healthcare is the way the workflow around the model is going to be designed. And sometimes, in my judgment, there are unrealistic assumptions made about how humans are going to behave when they interact with this tool. One thing we know for sure is that humans have a tendency toward automation bias, meaning we tend to over-rely on computerized decision support. We don't spot errors when we should. And when we do suspect an error, we don't intervene as much as we should. And when you layer on the life of a busy physician and the fact that this thing was probably adopted in the first place because of some sense that it would save time, there's a real risk of being a little bit too rosy about how we think humans will behave in practice. And that's, assumption is the mother of all problems. These are kinds of assumptions that we have to examine very, very critically when we think about what is the risk of deployment of this tool in my clinic. That's just the beginning, though. I think the second layer of risk assessment, and the one that gets missed a lot, is thinking about the opportunity to catch errors if they do occur. This is fundamental in the field of patient safety generally, but it has not permeated AI safety evaluation very much. So we know from other kinds of adverse events that there's the likelihood that something bad will happen, an error will happen, and then there's the likelihood that it will reach the patient. And a lot of these things end up being near misses because they're caught, either by humans or by other systems. So we have to ask, in the context of a particular AI tool, what's the opportunity to catch errors? That has to do with coupling. How tightly is the output of the model bound to something that's going to happen to the patient? An infusion pump, that's pretty direct. Something that is just informing a treatment choice alongside lots of other things, and there's going to be a process of reflection, that looks a little different. Similarly, the time sensitivity, how much time is there for a clinician to interrogate the correctness of the output of the model? And then situational opportunity, even if time permits, how likely is it, based on what we know about humans, and physicians in particular, that a person would detect and intervene in response to an error? So how prone are people likely to be to automation bias, in other words? Only then do I think we have to get to the risk assessment that the FDA uses, which is just this yellow box. That's all they focus on when they look at it, at the risk associated with the tool. Those are both super important because they affect the severity of the harm that could be caused if that error is not caught. but I think these upstream factors are just as important. And then finally, there's a bunch of things that lawyers would layer on. If you're asking me, what's the liability risk? That's a function of two things. It's the function that the probability that you hurt somebody, and the probability that their injury finds redress in our legal system, which most injuries do not. So here are lots of factors that affect the likelihood of somebody's injury finding a home in the tort liability system. And one thing to take away is that some plaintiffs are more attractive than others. The severity of the injury is the most attractive feature. When we look at garden variety medical malpractice claims, 85% of them involve serious injury or death. So most people have minor injuries. They do not consider them minor, but from the judiciary's perspective, minor injuries don't get into tort. And then the other thing is that because plaintiffs have to prove their case, they have the burden of proof. It may be that the most risky or most error-prone AI tools are not the ones that are the highest liability risk, if those faults are hard to prove. The injuries that will get compensated are the ones that can be proved. And so again, if you've got a very opaque algorithm, a lot of those errors may simply not make it over the bar for compensation. And that should also make us really skeptical about the tort liability system as an ultimate regulator of the safety of AI. You know, a lot of people say we don't need the government to do formal regulation because to the extent that there are safety problems, the courts can provide compensation. I think that's just wrong for all these reasons that have to do with the difficulty of proving a claim. And then finally, I'll just reiterate the point that your liability risk depends not just on all this stuff, but on how much you can shift the buck onto other defendants and onto the patient themselves. So for some of these kinds of tools, you know, there isn't an external developer to assume liability. They're homegrown. We develop them right here at Stanford Healthcare. For some of the tools, most of the errors would arise from a human interaction, a human decision that's based on the tool. Other tools, it might be that, you know, something that's internal to the tool where a human's not involved. That's more of a developer liability issue, whereas the first case is more of a physician liability issue. So there's all kinds of variables in play. And again, my overall message here is that you shouldn't think of this as a monolithic judgment. Am I going to be liable or not, or is it high risk or not? But something that very much depends on all of these factors related to a tool and should lead you to ask hard questions when you make decisions about whether to adopt and use it. So that is my first recommendation, is just be very surgical about how you think about liability risk. Speaking to those of you in the room who might be part of institutional leadership structures, when you're evaluating whether to accept a tool into your clinic or adopt it at the institution, I think that there are a number of things that can be done to minimize risk. It's a buyer's market right now. As you probably know, there's so many vendors out there trying to sell. They would love to sell to a high-profile system like ours and be able to put that on their website. So I think there's an opportunity to bargain for terms in licensing agreements that are favorable to the institution. I won't spend too much time on this because I imagine it's not of great interest to you, but you can have contracts require the developer to do stuff like provide information that would enable Stanford Healthcare to do really robust monitoring. You can make the developer perhaps do the monitoring itself and provide audit reports. You can make sure that those contracts don't immunize the developer, as many of them do. Say the developer is not liable, it's all on the hospital. And you can require that the developer has adequate insurance to take care of things that may arise. Finally, you can check behind the general terms of use that the developer has for its product to make sure that they are not going to screw you. To take one example, this is OpenAI's terms of use for ChatGPT, which of course we use at Stanford Healthcare. Take a look. You shouldn't rely on model output. You should not use it to make medical decisions. If we let stuff like this stand and then contract for use of products, we are taking on liability, and probably liability that we don't need to take on. I'll say one more point about insurance because it's super important. making sure that this developers, particularly small companies, have really deep insurance is super important. And it's also important that we think about our own liability insurance. Most of those policies were not written with AI risks involved. Smart insurers, if you sort of look around in industry newsletters, are starting to think about how they could carve out AI-related harms as special, like, or require extra money to be paid, like the way I have to pay extra money for my pool at home. And so it's really important to make sure that there isn't that kind of carve out. Some organizations might think that their cyber insurance covers this. It generally doesn't. So we don't want insurers to be ahead of us in anticipating and disclaiming risk. It's also important, I think, for physicians to start anticipating some of the evidentiary issues that might come up if you're sued. Documenting what that model output was and why you thought it was reasonable to rely on it or to reject it, I think is very important. And then just understanding and really confronting your own automation bias over time as you come to trust a tool more. Stay skeptical, especially if it's a tool that's based on evolving training data, like a GPT, or on training data that you know don't match your pediatric population. None of this should make us feel like we can be asleep at the wheel. Automation bias is becoming increasingly important in my view also because the legal standard of care for medical malpractice is shifting. So for a long time, what the law requires of you was that you render the care that a reasonable practitioner in your specialty would render under the circumstances. That's just medical custom. It's been that way for at least 5 decades. Last month, a bunch of very smart lawyers got together and reviewed all the case law in this area to come up with a new version of what we call the restatement, which is a sort of definitive statement of what courts are doing in a particular area. And their judgment is that this standard of care has now shifted. It's related to medical custom, but it's not the same. And this is the new formulation. And the key distinction is this. And where this interfaces with automation bias is that it's not going to be a defense to say, well, you know, we've been using this in-basket tool or whatever for a while. We think it works pretty well. So I've actually stopped editing it very carefully, and so has everybody else. If it's wrong, it's going to be much harder to make that kind of an argument under this new standard. Finally, I think it's really important, as I said, to ask hard questions when you're being asked to use a tool or to adopt a tool. Every discussion that I've been in about institutional adoption of these tools ultimately assumes, again, at the end of the day, that the human in the loop will be responsible. And that also means liable. I don't think that there's a bunch of other parties lining up to protect physicians from being liable here. And that means that you should be very skeptical when you're being asked to adopt a tool. Ask questions about how it was trained. What do we know about where it works well? What do we know about where it doesn't work well? And how will I be sure that you'll tell me when that changes? Finally, a word about informed consent. I haven't actually made up my mind about this issue of whether patients should be told or asked about use of AI in their care. I think it's a really interesting issue, and it has legal implications because in addition to bringing a regular medical malpractice claim, a patient can layer on a separate claim for breach of informed consent. That means additional damages and a different pathway to liability. You know, if an AI tool was used in the care, it's going to come out in litigation if it wasn't disclosed. And so that raises kind of interesting questions to me about what patients should be told. And again, I'm still sorting this out, but here's kind of how I think about it. There are a bunch of really good arguments against, and there's a rebuttal to each of those arguments. What I keep coming back to is that in California, the legal standard of care for breach of informed consent is what would a reasonable patient have considered material to their decisions about their care? Not what you think. Some states it's what you think, but here it's the patient. 60% of patients are uncomfortable with AI being used in their care. I think you put those two things together and there is a cogent argument about breach of informed consent if it was something that we think a patient would want to know about. And there are always lots of good reasons not to have to spend time on this in a conversation, especially because we know distrust of AI is especially high among Black and Hispanic populations, who may also have the most to gain from assists in their care and augmenting physicians in underserved areas. But I think it's a really interesting question to think a little bit more about, and that there probably are tools that patients ought to be told about when a treatment recommendation is being informed by them. So I'll pause there. I'll just say that there's some more information about these ideas in this paper that I published with my student Neil Gua in NEJM earlier this year. But I'm very happy to take your questions.
All right, thank you. So I think there's going to be a lot of questions. And for people on Zoom, this is Mary Leonard. So a few months ago, the whole Accept I paper came out with Alyssa Burkhart talking about the whole lack of pediatric data and all of the ethics and algorithm bias. So she came and spoke with us. And so the whole issue of the lack of pediatric data is incredibly important, and we're trying to figure out how we can work with different entities across campus to tackle that. But a related question, and I want to thank Sanu Israni from the Presence Program, is also the health disparities and health equity piece of this. So her question is, are there data indicating whether there are disparities in AI adversity, possibly further exacerbating existing inequities in healthcare?
AI adversity. I'm sorry, did I hear that?
Yeah, she used the term AI adversity. It was a question I had planned on asking about health equity and health disparities. And if your learning data set is one demographics and you applied in another demographics, for age notwithstanding, which is sort of the 800-pound gorilla in the room for this group, what are the potential implications for health inequities or health disparities from these tools?
Yeah, well, I mean, again, I think it probably it varies from tool to tool, but there's just so much literature that drives home the point that tools perform well for those on whom they were trained. And we just have lower representation of particular demographic groups in the training data, including Black, Latino, Native American populations, and there is underperformance for some of those. There are probably also lots of other demographic groups that are underrepresented in data that are quite salient, medically fragile patients, kids, people who speak limited English, et cetera, that we should be thinking about. But at the same time, I think we do recognize the potential for some of these tools to extend the availability of healthcare to populations who are living in underserved areas. So to me, it's very much about balancing those things. And I think the take home for physicians is, your baseline set of priors is you should be particularly suspicious about relying on tools for patients in those populations that are likely underrepresented in the data set. And you should ask about their representation in the data set for this tool that your institution wants compared to the patients you see in your clinic. Lee?
Oh, it was Lee Sanders from General Pediatrics. Michelle, this was a great summary. Learned so much, particularly about the current standard of care. I have a question about the future standard of care. When and how might it be malpractice to not use AI tools in care? Yeah, so I think this general standard of care applies very much to that question. So at some point in some areas, it will no longer be regarded as competent to not use it. And I think that probably the closest we're getting to that is in certain kinds of imaging, where it's so prevalent to have AI embedded in a device that if you were using it, I don't even know what the lifespan of, you're using an older device that doesn't have it, it would be hard to defend. If 90% of mammography is done with an AI assist and we know it's better, that gets hard. But I think it doesn't have to be quite customary yet under this definition. It might fall a little bit short, but probably we're not close to that now for most things because they're just still pretty rare.
But what I'll add about the imaging, so the American College of Radiology has put out a white paper on this, and they have something called Image Intelligently. Of the more than 200 AI software that are cleared by the FDA as a medical device, only 6 or 3% were intended for pediatric use.
Yeah, wow. Hello.
Hi, Michelle. John Klein from Adolescent Medicine. Thank you. That was a great talk. What I kept thinking about was the practice that has gone on to varying degrees for many years in the surgical specialties, but also for our cardiologists, for example, of a technology or a device being brought in and trained by someone in a case where someone is operating on someone, for example, which creates, it's an act rather than an omission or a decision. So it's a more clearly defined action, but that liability created by trying a new device, which may be an approved device, but the technology to use it was often being assisted by a representative of the device, even in real time in the operating rooms. And so the analogy here is that the AI device or software is providing that same assistance, but you don't necessarily know that it's in the equipment that you're using or the decision tree, or maybe you do, but increasingly I suspect people won't know. And it's not clear that that is as easily discovered or deposable when it comes to what the device is actually doing.
Yeah.
So where do we go with that, and how do we put that into education as well as risk assessment?
Yeah, it's a really good question. I mean, for me, it all comes back to the reasonableness standard. It's a very flexible standard, but it is meant to account for things like there was no way I could have known, which is why I've been saying it's so hard for plaintiffs to prove a defect in these cases or unreasonable behavior. Having said that, I think that a lot of imaging manufacturers, for example, when they bring their trainers in now, they tell me they do talk about the AI assist and what it's all about. I don't know what they say or how thorough it is, but I think that people who make physical devices are going to have to start incorporating that into their training and certainly into the disclosures that they make about their product. And the second thing is that although physicians, I think, would often be insulated from liability in a situation where they really didn't know that this thing was in there, there is also the hospital. Somebody is making a decision about buying this MRI or bringing in this tool and plugging it into the EHR. And that's where liability ought to be focused, because they're in the position to know what questions to ask and to get the answers before they turn over money. So if the liability system functions well, then particularly in an entity like Stanford, where there's this unity of employment, it should be possible for there to be liability in those cases where the hospital didn't do its due diligence without visiting it on you. In other situations where physicians have separate employment, separate insurance, there's more likely to be fights at the defense table about that. But a responsible institution should step up if it's something that they didn't tell clinicians about.
Michelle, thanks very much. I'm Denny Lund. I'm the CMO at Packard, and I sit on both of our insurance company boards. And I see a whole new world of litigation coming related to AI. One of the questions I have for you is a little bit related to Lee's question about when is there culpability for not using AI in a medical decision-making process. But the other thing I'm kind of interested in, we make the assumption as physicians that we will be the ones bringing AI into the physician relationship. But the fact of the matter is, as we all know from Dr. Google, is that patients are going to be going to ChatGPT or Apple Intelligence or whatever is going to be the newest thing, and be bringing suggestions for their care to physicians that have been generated by AI. I'm just kind of interested in what your thoughts are about that and how physicians should be reacting to that.
Yeah, it's really interesting. I mean, I have heard physicians say that looking at GPT was really helpful because it helped them remember some obscure thing that they hadn't read about since medical school. And so maybe it's irritating when a patient comes in with some kind of suggestion like that, but I don't think it's that different from what you're facing already with patients looking for information online, except that they may end up getting routed to less reliable information. What really interests me is when physicians refer patients to online tools, direct-to-consumer online tools, instead of doing things that they would ordinarily have done. Like I talked to one prominent physician who says he's a surgeon, and at discharge, he'll give patients kind of basic instructions, but basically tells them to go chat GPT, what to look for if they're at home and something bad seems to be going down. And I thought, really? So I think maybe the most immediate strategy is like, don't encourage patients to go out and use ChatGPT for information that you should be providing. I have also heard it said, though, that it might be useful to help patients understand the instructions that you are giving them. So, for example, for young children, if you have a set of discharge instructions and you want them to understand the basics of that, you could ask ChatGPT to translate your instructions into something that a 7-year-old would understand. But I would be very leery right now of involving patients more in those tools. And I think as far as stuff that they're bringing into a medical visit, it's just the same forbearance that you've already had to show to Dr. Google.
Okay, so we have a few more minutes and we have lots of good questions. I will say that Grace Lee, our Chief Quality Officer, and Natalie Pagler, our Chief Medical Information Officer, are both at Epic today and couldn't be here, but they send their regards. Okay, so you mentioned inapplicability of disclaimer in terms of use. Mm-hmm. Can you clarify which types of consent can be included and legally valid in terms of use and which cannot?
Yeah, so it's not consent. What this would be like when the hospital is licensing a tool from Epic or wherever, they're going to have a licensing agreement, and it may have some kind of disclaimers in there about what Epic can be held liable for, as opposed to the hospital or the physician. I talked recently with someone who has a leading practice in software and AI in Washington, D.C. about this issue. And it was her feeling that these disclaimers right now are pretty enforceable. And she uses them all the time for her clients, her corporate clients. So I think, all I can really say is be on the lookout for them and push back when you can. If it's Epic, it's hard. If it's, your college buddy's startup, it's easier. Mm-hmm. And so I think we shouldn't forget that these are potentially negotiable.
So the next question sort of builds on something that you made very clear, obviously, that AI is fundamentally different from other tools in medicine. As with most AI, there's no way for a person to review the inputs and outputs, reach the same output, i.e. there's no way to explain the black box. And I know you talked about that. That being said, why should a physician take the liability? Losing a lawsuit is not the only concern. Just being sued is a harm to the physician in and of itself.
Absolutely. I mean, physicians, when you ask them about this issue, they will compare the experience of being sued to the experience of losing their parent in terms of how horrific it is. So I in no way want to minimize that. I think the fundamental question is why should I use tools in light of this liability? Is that how you interpret the question?
Yes.
Or why should, I think so. I mean, if the question is why should physicians be held liable, I don't think they should. I think there needs to be a fair sharing of liability across physicians, the hospital that chose and maintains the tool, and the developer that made it, according to what the nature of the error was and what was reasonable or unreasonable. But at the end of the day, it is not necessarily a liability reducing strategy to never use this stuff, because we make a lot of errors right now.
Yeah, because they said, why should a physician take the liability? But I think as a lot of these things are implemented in the hospital, I'm not sure you're going to have a choice.
That's true. I think maybe the person meant that why should liability ultimately rest on the physician?
Oh, right.
And it's not fair, and it hasn't been fair for a long time. This is the way it is with medical malpractice, because a doctrine called corporate practice of medicine just makes it harder to hold the hospital liable for most things that physicians do. This is different to me because it is not always about what physicians do, or at least about what they do unreasonably. It's about the choices that are made at the institutional level, about the care environment that they're going to encounter, including, again, are the assumptions made about that workflow realistic? Is this, like, the people who are experiencing this, do they agree that all of these checks and balances that humans in the loop are supposed to provide are going to happen in this workflow?
Yeah. Okay, and then the last question about another doctrine. Are you implying that the doctrine that, quote, the injury speaks for itself, end quote, is itself succumbing to technological change and product opacity?
I'm not entirely sure what they're referring to, but perhaps the sort of feeling that people who have serious injuries get compensated even if there isn't negligence. That is a feeling that a lot of physicians have. It's not actually empirically that accurate from what we have been able to observe about the medical malpractice system. But it remains true that because most of these claims get settled, not tried, institutions may be more interested in settling very serious claims, especially serious claims involving kids and AI. Is that going away? Probably not if it arises from an impulse either to, to care for families who have suffered devastating injuries or to keep things out of the newspaper. An institution could take the position of, hey, it actually seems like these are going to be super defensible if we are willing to fight to the death, in which case I think there is greater opportunity to reduce payments to people who don't qualify for them.
Okay, well, I want to make a plug for the MCHRI annual symposium in the fall, because Michelle is going to be one of our keynote speakers talking about disinformation. So we'll have more chance to talk to you. Really grateful for the conversation today. Both the Maternal and Child Health Research Institute and the Department of Peds really want to lean in to the unique challenges in pediatrics. I'm really grateful for today's grand round. So thank you.
Thanks very much for having me.
The preceding program is copyrighted by the Board of Trustees of the Leland Stanford Junior University. Please visit us at med.stanford.edu.